Dolores Fund, Rate versus Evolutions Holding, and 3 other defendants. For the plaintiff, Attorney Sobczak, and for the defendants, Attorneys Ryan, Matheson, and Polderman. For the receiver.
Good afternoon, gentlemen.
Good afternoon, Your Honor.
We do have competing motions for summary disposition. I thought what we might do, unless there's opposition, that would take Mr. Ryan's motion. It's a C7. It looks like it's the easier one to get through, maybe, and then we'll go to Mr. Sobczak's motion, unless you want to change the order.
I'm unclear on your reference.
Yeah, I didn't file a motion.
Oh, you didn't?
No.
Glad to hear that, man. That was scary for a minute there. Woo, buddy. All the time I spent getting ready.
Okay, well, then that was, I thought I saw.
Your Honor, I asked for relief under 2116I2. I don't know if that's creating any of the issue here, but that would be secondary to Mr. Sobczak's motion.
No, I had one. I thought, Mr. Ryan, you filed as related to binding arbitration.
Oh,
Yeah,
I did file that, but that technically that was filed on behalf of Evolutions, which the receiver now possesses.
Okay.
Not on behalf of the individual defendants.
Okay. Well,
but
good.
if you were going to grant that,
no, what happens is they gave me all the motions, they gave me all of the replies, and so I had that one, and that's why I had it.
It would make it very quick today, that's for sure.
Okay. Well, then we'll let Mr. Sobczak proceed with his motion in this matter.
Okay, lot of wood to chop today, folks. So, Your Honor, I have 3 motions. I have a motion for summary disposition under C10 against the entity defendants who are part of the receivership. They are unrepresented by counsel. Mr. Polderman is here as the receiver on their behalf, generally. I have another motion for summary disposition under C10 against the individual defendants. That's Mr. Lavender and Mr. Flocken. Relative to their guarantees and other related claims. And I have another motion under C10 relative to intervening plaintiff Speckin's claims to the collateral that, we position as being part of the receivership estate and subject to the bidding procedures order that Your Honor already entered. So I think there's some overlapping issues, and I don't want to make this any longer than it has to be. I think the easiest way to start is the motion relative to the entities, because there was no response filed. And I am prepared to walk through the entirety of our motion and argument, but I wonder, without putting him on the spot, whether it makes sense for Mr. Polderman to speak up first, because honestly, my first position would be that there's no opposition to this motion, unless somebody tells me there is.
Okay, well, why don't we do that and let Mr. Polderman? We did at some point have Mr. Spiegel. Wasn't Mr. Spiegel representing Speckins?
No, he represented intervening plaintiff Trainer, who doesn't have
that's right.
Yeah,
okay.
He's got nothing to do with any of these.
Okay, I'm sorry.
That's okay. There's a lot going on.
Yeah, I had his name down here, and I wanted to make sure that we weren't missing him. Okay. Well, then I'll let Mr. Polderman go ahead and see where we're at.
Good afternoon, Your Honor. John Polderman on behalf of the court-appointed receiver, Charles Bullock. So in any receivership, the receiver has the judgment call to make as to whether he's going to step in and represent the entity. And I would say that that's usually highly unusual because there's a distinction between the entity and the receivership estate, and the receiver is typically neutral as to the underlying litigation between the parties. And the receiver could pay for counsel for the entity if he thought there was a cost benefit to the estate, or he could sit by while the entities retained counsel and pursued claims or defended against claims. So in this case, the receiver is not representing the entities for purposes of this motion. The receiver has reviewed the pleadings and the responses, does not believe in the exercise of his business and legal judgment that he has grounds to oppose those motions on behalf of the estate. I think the receiver also has at least perhaps a basic duty just to ensure that the claims asserted against the asset have some sort of backing and that the dollar amounts asserted are supported. I do note that the complaint was a verified complaint. We did review the pleadings to see if there was an affidavit, and I do know that that initial complaint was verified as to dollar amount. So all that to say is we're not opposing the motion as it relates to the entities. I don't believe we have grounds to, and to the extent that the entities wish to retain counsel of their own choosing and appear here today and defend, we certainly won't get in their way.
Okay.
But as noted by the court, there is nobody appearing on behalf of the entities. The receiver declines to do so, and just kind of 10,000-foot overview, doesn't believe, based on the fact of the verified complaint and the pleadings, that he has grounds to raise an objection.
Okay.
If I could really quickly, Your Honor, to
Go
provide
ahead.
some context, right? So the entities are insolvent, right? My client has put in money repeatedly over the last several months, which Mr. Polderman can attest to try to prop it up or to just maintain the collateral pending, the liquidation outcome of this receivership. So it's not as though anybody here at Polaris thinks that these judgments, we're going to collect per se. The issue is, though, whether we foreclose or there's a bidding process, we're entitled to credit bid, and that's per the Receivership Act, per Your Honor's prior receivership order. And I thought it most appropriate to try to secure a judgment as to the amount of funds we would have available to credit bid to avoid any later complexities or holdups with that process. And you might remember, Your Honor, when intervening plaintiff Trainer, who isn't here today, asked you for relief from the stay so he could go get a judgment against these same entities. The way that turned out is Your Honor said, well, no one's going to defend him, so there's no harm to the estate. What's the difference if he gets his judgments and then brings them back to this case and we go from there? That's essentially what I'm trying to do here. I could have moved to default the entities for failure to file an answer to my First Amendment complaint, but instead I fully briefed all of the facts and arguments because I want the ruling to be on the merits, or at least to have made a record of the merits so no one can claim later that I didn't. Mr. Polderman's correct. The complaint was verified. It's very lengthy. It quotes all the loan documents. It's got a number of attachments. And I would also note that our motion quotes and references, a number of discovery responses, motion practice, admissions and the like that further support the claims. And so, this one is easy in my mind. I do have some comments on damages and how we can get there. But before that, I'd yield back to the court.
Okay. Well, let me go through. Mr. Ryan, do you have any response before I go back to Mr. Sobczak?
The only response is that I'm not retained and don't represent the entity defendants. There may have been a time when I was, but I think I even filed a motion in this case to withdraw as counsel for
That's correct.
Evolutions.
Yes, yeah, you did. I just, because you were here, I wanted to give you that opportunity
Well,
to respond.
sure. So I don't have a response, I guess, because I'm no skin in the game here. So.
Okay, great. Mr. Matheson, your response, if any.
Yeah, I'd take the same position as the latter one of Mr. Ryan, which is I've got no dog in the fight as it relates to Mr. Sobczak and the entities and the damage claims that he's seeking there. So whatever that judgment is, I assume it's supported by the record that Mr. Sobczak is presented. So I guess we don't have a specific objection, or we're not consenting to it. I guess we don't have a position on the matter is
Okay.
an accurate way to put it.
Well, Mr. Sobchak, you have made this a lot easier than when I got all the documents and I started reading all of these, which I did, and took me a number of hours to go through all of those. It seemed like it was much more complicated than it is today.
For this motion, it is rather simple because there's no counter argument. I do want to point out, you know, the damages that we alleged in our First Amendment complaint, that number was from a long time ago, as your honor knows, and as is supported by the receivership order and your prior order. Interest has been accruing this whole time. In addition, we've spent other money, protective advances, and the like from that time to present. So what I would ask of the court, and what I think would make the most sense if everybody was in agreement, is if you grant this motion under the 7-day rule, I will put together an order and I will support it with a present day calculation of damages and give backing for that calculation and an affidavit, if he wants it, to Mr. Polderman. And I think it would be for him to determine whether the math looked right or not, which, you know, he knows how many protective advances we've made, and we can provide other evidence of the number. But the point is, if we're doing this thing and we're going to do it the right way, it should be the number as of today, not the number as of several months ago.
Correct. And I know that the advances have been made because we've talked about it in other proceedings. So, Mr. Polderman, what do you think about presenting it in that way under a 7-day, and then you'll have a right to object if the numbers are not correct?
That sounds efficient, Your Honor, and I agree.
Okay. Mr. Ryan, I don't assume you have any opposition.
No comment.
Okay. Mr. Matheson.
No objection.
Okay. Well, it looks like it's almost a one-man show, Mr. Sobchak. So
Only for this one. We're just getting started.
okay. The court will grant your motion in this regard and allow you to proceed and submit a order for summary disposition, and with your damage amount up to date, and then Mr. Polderman can object if he needs to object.
Fantastic. So that is one of three. I think if everybody agrees, I'm going to move on.
That's the one with the entities, correct?
That's the one with the entities. So
Okay.
I think it now makes the most sense to move on to my motion against the individual defendants. That's Misters Lavender and Flocken. And
Okay.
this motion is predominantly, you know, while I have several counts and several claims, just for the sake of the argument, this is predominantly about those individual defendants' personal guarantees of the loan.
Okay.
And, you know, I want to point out that they have also made this very easy for you, in fact, because you would note in our reply that we attached a separate motion that Mr. Ryan filed in a different case this year, extremely recently, asking for those same two individuals to intervene into the quiet title action, which you might recall is the whole
Yes,
Holland
I
thing.
do.
And in that motion, the basis for his request that they can intervene either by right or permissibly is that, and I'm quoting, the individual defendants personally guaranteed the construction loan issued by Pelorance, and it is now in default. Period. So I just want to start there because, you know, Attorney Ryan's response is complex and it muddles things, and it's going to take some time to pick apart. But I just want to point out to you that it's difficult for me to understand how they can contest my motion today when roughly a month ago in a different court, they filed, a submission saying they know they personally guaranteed this. And for that reason, they want to intervene in this other case, right? That's the starting point. And that's, again, our reply, Exhibit A, page 2, is the filing that Mr. Ryan made in that separate lawsuit. Very important.
Where's that? So I could make a note of that, because off the top of my head, I don't have the reference.
The reply, my reply brief, the opening paragraphs of it discuss this, and Exhibit A to that reply brief is a motion to intervene filed by Attorney Ryan right here on behalf of Lavender and Flocken. as of January 2nd, 2025. And it says again, Lavender and Flocken personally guaranteed the construction loan issued by Polaris Fund REIT, and it has, circumstances have led to a default of the Polaris construction loan. So, I appreciate that Attorney Ryan's here trying to represent his clients, but it's really hard for him to get out from under that. You can't talk out of both sides of your mouth at the same time in court proceedings. Things get a little weird when you do that. The next point I want to make is in this motion, I cite a number of discovery responses and other prior submissions to Your Honor that were on behalf of all the defendants, including the individual defendants, and which I believe further support the relief I'm asking for in the motion. The only thing that has ever happened that, these people have tried to deny any of this was in their answers to my first amended complaint, which you might recall I was trying to default these to 3 times, right? And we didn't get that through, and then they filed the answer. That answer neither admits nor denies every single allegation in the complaint, which is really long. Like, every single one says neither admits nor denies for lack of information and understanding. This is that is a lot given the prior discovery and the prior admissions, and the fact that some of those allegations concern actions taken by Mr. Ryan and whether or not he was even a lawyer for these people at any given time. How does Mr. Ryan and his clients not know and not have information to admit or deny something like that? So I think that to the extent Mr. Ryan's going to point to the answer to the First Amendment complaint, one, they can't simply rely on pleadings at this stage of a C10, and 2, I mean, it's just not believable, right? They can't have selective amnesia when trying to save themselves from this outcome. The only 2 substantive affirmative defenses that are put forth by these folks are 1, Polaris committed a first breach here, which is absolutely nonsense, and 2, that there's a question of fact based on these affidavits that were submitted, but they really only deal with the fraud claim against Flocken, which I'm going to talk about later. And Lavender's affidavit doesn't really talk about the personal guarantees at all, and I don't understand the relevance of it. I can keep going and get into more detail, or Your Honor can ask questions, or however you think it's best to proceed. I have a good deal more to say, but I want to, move stepwise here.
Okay. Well, why don't you proceed, and then I'll get Mr. Ryan, unless you want to interject at this point.
No, I'll let him finish. Go ahead.
Okay. Go ahead.
So, Your Honor's sitting here, and you're thinking, okay, I'm going to, grant this judgment against these 2 people who guaranteed this loan allegedly. How do I feel comfortable doing that? First and foremost, I want to point you to the actual loan documents. My First Amendment complaint Exhibit 3 is the initial guarantee. It is absolutely signed by hand by Lavender and Flocken. It is an exhibit to the FAC. Their signatures are on it. No one has ever said they didn't sign that. The First Amendment is also signed. There is this continued super annoying argument interposed about how the attachments to the First Amendment were individually assigned, so nobody knows if they're real. And I'll get to that later, but the actual First Amendment itself was definitely signed. Furthermore, that First Amendment, in spite of that signatory argument, was ratified by their attorney at the time, who Polaris forced to, required to give an opinion letter on the topic. And that's also attached to both my motion and the First Amendment complaint. Lastly, everybody signed the Second Amendment, and Attorney Ryan sent an email to Polaris, which I have also exhibited and attached. That's Exhibit 19 to the FAC, where he says, I am signed off on the Second Amendment. That is really important because the Second Amendment both ratifies and reaffirms all prior representations and warranties and waivers and releases, including as to the guarantee obligations and including any waivers and releases of defenses relative thereto. That's it, right? I don't understand how, and I will pull it up and I'll screen share it, but I don't understand how they can get away from that. The request to admit responses on behalf of all defendants, they were absolutely on behalf of all defendants. say the First Amendment was signed, the Second Amendment was signed, the restated notes were signed, affirm the releases, admit that there was, a title defect, and agree that there was failure to make payments. The response to the renewed receivership motion, with which Mr. Ryan filed, says that these folks know the loan matured, they know Polaris is trying to recoup the money it lent, and they know that interest is owed. This is in the court's record already. Finally, there's the answers to the FAC, which don't contest any of that. They just say all of a sudden now, we neither admit nor deny for lack of information every single thing in your complaint, Mr. Sobchak. Your Honor, you can take that for what it's worth. Again, on the affirmative defenses. One, this has all been waived. These are sophisticated commercial loan documents for many millions of dollars. They have waivers and releases of counterclaims and setoffs ad nauseum throughout them, including the ones specifically signed by these people. Polaris does not loan money or amend loan documents or give people more time on maturity without getting those waivers. That is standard practice in the financial world. It shouldn't surprise anybody here. That aside, to the extent we still want to talk about this stuff, the first and major argument here is that Polaris committed the first breach. And so somehow like we're out to dry on all of these millions of dollars. The concept here, Your Honor, is as it's pleaded in our FAC, the title defect that was the Howland quiet title action was discovered on the 11th hour of the increase to the loan. Okay. The argument is that Polaris should have known that in light of that title defect that they would default on the loan. And so somehow that means we breached the loan agreement first. Aside from the fact that there is zero lender liability or obligation to borrowers in this capacity in Michigan, and no one has cited any case law to the contrary, Your Honor, isn't it also the fact that Lavender and Flocken also knew about the title defect and also knew that there was potentially a risk that it would tie up their ability to perform under the loan? Did they not knowingly take Polaris's money and spend it on their facility and sign these documents? So somehow Polaris is imputed with negative, connotations or action because we were like, well, if you think you're still good, we'll give you the loan. But the people who told us it was going to be okay and who also knowingly took the loan with lawyers involved are like absolved of any responsibility. At best, that's like both parties, took the risk on that. And let's remember, like my client is out many millions of dollars and we're not going to get it all back. And they're paying me a ton of money to fight with everybody here. So there's not like Polaris won anything. But all that being the case, how can Lavender and Flocken not be held responsible for also taking a loan that they should have known they wouldn't be able, their companies wouldn't be able to meet when we all had the same facts? And frankly, they knew way more about the Howland situation and the quiet title problem than Polaris did. We only knew what we were told. In the FAC and in the motion, I point out that it wasn't until many months after this First Amendment that the Howlands filed a counterclaim in that other case, alleging that the entire property, but for 1 acre, was up for grabs and in question. If we had known that was how serious this was and that it wasn't just going to be fixed with a corrected deed, we never would have made the loan. It's just preposterous to say we would have. The next argument here is that the title defect itself caused an immediate breach of the First Amendment. That no one's reading the documents, right? There's hundreds of pages of loan documents, but no one's reading them. The title defect was defined expressly as a permitted encumbrance in the First Amendment. That's First Amendment complaint, Exhibit 12A, Section 1.1, and then many others I cite in the complaint. No one's contested that. By its plain terms, that was exempted from the other reps and warranties that would have been defaults under that loan document because we did know about it. And they said that the Howlands were just going to sign a new deed and fix it. And it wasn't that big a deal. So we carved it out to make sure that they had time to do that. The only other argument I want to hit here, because it also comes up in Mr. Matheson's response, is this idea that as to the First Amendment, the supporting amended loan documents are not themselves signed, so nobody knows where they came from or whether they're valid or not. I have stated in the complaint and in every one of my motions how preposterous this is, and people continue to throw the argument at me without ever advancing the issue. No one's ever really responded to my position on it. They just keep saying the same thing. The point is this: the First Amendment is a 5-page document. Okay? At Article 1, it says, and I'm quoting, as of the effective date, the loan documents are amended as follows. And then it lists them all out. Exhibit A, the new loan document. Exhibit B, the new pledge agreement. Exhibit C, the new collateral security agreement. And they're all appended as exhibits to that First Amendment. The idea that those are not valid documents is preposterous given that language and the way that that document was set up. And furthermore, again, Attorney Ryan sent us an email saying he was signed off on those forms. How in the world can we now all have everybody making this argument against me? And lastly, Your Honor, even if that wasn't the case, the Second Amendment came later. And the Second Amendment affirmed that the First Amendment and all of the prior representations, warranties, and promises were still valid, and it once again released and waived on Polaris. So even if that's the case, they still took the money, people still performed, they made loan payments, and then they signed another amendment. And yet I'm still being attacked with this argument, which is just starkly in contrast with the plain language on the first page of the First Amendment, and it's aggravating because it's wasting everybody's time. I do want to talk about Mr. Flocken's fraud claim because that is separate, but I think I'll yield to Mr. Ryan because looks like he wants to get in here and start saying some things. The point, Your Honor, is the loan was made. Polaris required personal guarantees from these gentlemen who were in charge. They have signed repeated pieces of paper. They have submitted repeated filings to various courts, all stating that these guarantees are legitimate. And we are where we are now, right? I want judgments on the guarantees, and my client's entitled to them. And all of this mess to try to avoid that outcome is just, smoke and mirrors. Yield to Mr. Ryan.
Okay, Mr. Ryan, go ahead.
Thank you, Your Honor. First of all, Polaris is not exactly the victim they're painting themselves out to be here. You know, this thing started because of it's a construction loan, really. And what had occurred here was that the first part of the loan was made, $4 million. There were documentation signed, but then it came time for the second. Well, thereafter, my client at the time, Evolutions, purchased the remaining acreage, or tried to purchase the remaining acreage on River Road there, and ended up, because of an error committed by Sun Title, which was discovered by Mr. Sobczak's client before the loan was executed, that the wrong property description was attached to the warranty deed. And so I point out that they're not exactly the victim they paint themselves to be, because with this knowledge, they went ahead and made the second loan. And then they demanded that Polaris, or that Evolutions, obtain quiet title. First, they tried to get Sun Title to get them quiet title, but that couldn't happen. There was an effort to fix the error through a Scrivener's error filing by the title office, but that was insufficient. So pressure was put on Evolutions to obtain quiet title from the Howlands, and that lawsuit was started in January of 23. This error was discovered in July of 22. And to back up again, Sun Title committed its error in January of 22. So you've got the error committed by Sun Title. You've got this, no one knew it. They got the discovery of the error by Sun Title that's discovered by Polaris in July. And then you've got the final documentation for the loan done in August. They knew, Polaris knew at that time, or should have known at that time, that without clear title, there would be no way for Evolutions to then, once a certificate of occupancy was submitted, or once the building was completed, sufficient that Evolutions could go out and get a mortgage. They should have known that it was impossible without clear title and with the presence of a quiet title action to get the mortgage financing. Evolutions went on then, or I'm sorry, Polaris went on and then commenced this action in June of 2024. After the quiet title action we were wrestling with that the whole balance of 2023 and the first part of 2024. So that's the background here. And I want to point out that they are not the victim that they paint themselves to be. Because of this irregularity in the issuance of the second part of this loan, the guarantees are defective. It's an impossibility. And I could argue this one of two ways. I could say that this is an impossibility, that the contract is void, or the second part of the contract, if it's a second contract, I could say it was void. But I think it was more appropriate to say that they were the first to breach, because I see it as one contract or one loan that had two parts. So they breached it when they went ahead with it, instead of putting on the brakes and saying, hold on, let's fix this so that we are secured. I think that their actions have consequences, that they took a risk. They knew what was going on. And because of the defects there, you've got defects in the guarantees. So, or at least we've got an issue of fact, and they're not entitled to summary disposition at this time. I've also pointed out, and I think Mr. Matheson has adequately pointed out as well, that there is issues of fact with regard to the security for the second loan. Now, Mr. Sobchak wants to go ahead and proclaim that I sent an email and somehow approved it. I wrote an email in June of 23. Keep in mind that second loan was done in August of 22 before I even knew any of these people. My email, and it's Exhibit B to his motion, says I don't have any objections to a loan modification that was occurring at that time, or a loan amendment that was being discussed at that time. So that's what that is. And I don't, he makes it sound as if, oh, I signed off on this and therefore the guarantees are fine. Well, how could they be? I wrote it in June. That's in the exhibit, and the loan was commenced in August. So, yeah, back to the security for the collateral, or the collateral security agreement. We've looked high and low. I've got affidavits submitted by both of my clients. They can't find it. We backtracked it and pulled out the original paperwork that shows that the collateral, there's errors in the documentation is what we're pointing out here. I also want to point out that Lavender and Flocken did not directly benefit from these funds. Lavender and Flocken they're the guarantors for Evolutions. This is a construction loan. Payments are made on a draw basis. The money does not flow directly to Lavender and Flocken, and there's no proof that they personally benefited from monies from the Polaris funds.
Mr. Ryan,
Yeah.
don't know that there's anything in the law that requires that a guarantor personally benefit. I mean, if they're guaranteeing on behalf of their either corporation, LLC, other partnership, or anything of that nature, they're just guaranteeing the payment as opposed to anything else. So I guess I don't understand. You'll have to enlighten me as to how they need to have some benefit before they can sign a guarantee.
Well, the argument that Mr. Sobchak is making is that they're unjustly enriched. And
It's an alternative count, Your Honor.
I
It
would
doesn't
say that
matter unless you find there's no contract.
Go ahead. Go ahead, Mr. Ryan.
well, I'm just saying that there's no flow of money directly to these individuals, for which there would be, if there would be a valid unjust enrichment claim, but there's not here. And that's the basis of it.
But again, get back to my point. We deal in the business court all the time where corporations take out loans and let's say principals or whatever of those entities will sign a personal guarantee and the money never flows to the individuals. So I guess I still don't understand how that's interposed as a defense.
Well, it's interposed as a defense insofar as they were somehow unjustly enriched by.
Okay,
the
as it
funds.
relates to that alternate count, I understand.
Right, that's what I'm talking about.
Okay, okay.
So, yeah.
Can I
So
respond? Oh,
I think
sorry.
it's premature at this point to grant summary disposition to Polaris for these reasons. On these guarantees, there's certainly some risk that I pointed out that has not been denied by Mr. Sobchak. There was some, well, I'll leave it at that. It's just the motion should be denied for these reasons and the reasons I stated in the brief.
Can I
Okay.
Please respond.
Go ahead.
Great. Your Honor, it just got really easy. Attorney Ryan. just
You're
gave me-
coming through, you're
Yeah.
coming through very faint for some reason. I don't
Oh,
know
that's
why.
unfortunate. Can you hear me now?
Same here.
No, not very well. So
How about
You're-
now?
you were fine before, and I don't know why you're not now.
Oh, no.
That's fine. Now we can hear you.
Okay, I'm sorry. I have no idea. Sometimes I wish we just came to court again like the old days. But oh
Yeah.
well. All right. So firstly, they cannot keep their arguments straight because they don't make sense and they're disingenuous. In Mr. Ryan's counter, rebuttal, he first says there are defects in the guarantees based on this First Amendment signing thing, which I already prefaced and explained to you. But later, several sentences later, he said his clients are guarantors when talking about the unjust enrichment claim. It can't be both. He has admitted that they're guarantors. In the other filing, he just said it to you again because they are. Again, he says we looked high and low for a signed copy of the collateral agreement. It's attached to the First Amendment as an exhibit, and the First Amendment says all those exhibits are valid when it is signed, and no one is denying that those First Amendment wasn't signed. And that doesn't even matter. It's a complete red herring because they signed the initial guarantee on the first loan, and Attorney Ryan just said all of their arguments about why this is invalid only arise during the second tranche or the increase to the loan. So at a minimum, as we sit here now, at a minimum, he is admitted, and I am entitled to judgment against these two for their guarantees as to the value of the first loan and the interest relative thereto, which is $4 million and change plus whatever we are today. Honestly, these guys are not collectible, at least not up to that amount. And so whether it's 4 or 6 or 8, at some point, it doesn't really matter anymore. But I still think we should all get this right on the law. So I already just won my guarantee arguments as to the first loan and the initial guarantee, which is outlined in the FAC and was the first thing signed, and no one has ever claimed it wasn't. And everything else he said that they are guarantors. I'm also entitled to the guarantee on the second loan because, once again, the only two arguments are the collateral document wasn't signed, so somehow that impacts the guarantee. Makes no sense at all. Plus, it was ratified, and it is part of the First Amendment, and that's why it wasn't separately signed. And then Attorney Ryan walked right back into the argument about how Polaris committed first breach and how we're not the victim that we purport to be. But again, he didn't at all address the fact that Lavender and Flocken were the ones who bought this property from the Howlands and who knew what was going on. And when they were made aware of the title defect, they did not put the brakes on the loan or say, wow, we can't take this extra money. We got to sort this out. Quite the contrary. They said, listen, it's just a scrivener's error. We're just going to have the Hollands sign a new deed and we'll sort it all out. We can't wait. Let's do the loan. And Polaris was like, okay, man, we trust you, right? How the absence of any discussion about how they were equally aware of the situation as was Polaris is deafeningly loud at this point. So I absolutely get judgment on the first one. On the second one, their defenses and arguments are invalid, and they just keep saying the same thing. They never advance past the arguments I just gave to you in reply. And I think you can rule there as well. We
Okay,
do have
Mr. Stavcek, I did have a question on that.
Yeah, please. I want to hear.
Is that my thought is I'm reading through all the paperwork, and when again you did the advance to again pick up that extra acre from the Hollands.
Yeah, the increase, right?
Yeah. Once that's done, doesn't that eliminate the argument of the absence of this 1 acre once it's acquired? As I was reading that, I thought, well, geez, it's kind of like now it's been corrected. So what's
at our expense, at my client?
I understand that. I'm just saying, but now it's corrected. So it's a moot point that maybe the 1 acre was missed at some point in the proceedings.
I appreciate that observation by the court, and it is another reason why I think their defenses on this topic are, not really directly germane to the court's consideration. I just didn't want to come out the gate with that argument because I'm going to be portrayed as like, oh, Polaris just bought its way into like, no, we ended up paying for the 1 acre to secure this whole facility that these two guys owned, founded, operated, took a bunch of money from a ton of other investors and are getting sued all over the state over. Like, they are responsible for this situation. There's nothing in any loan document that says that their performance under the second, tranche of the loan was conditioned on their being able to clean up the quiet title action. They took that risk and they told us it wasn't going to be a problem. We gave them the money. They spent the money. That's all there is to it. The last point I want to make is, again, another reason why you can reject these, defensive posture is, okay, the First Amendment was signed, wasn't signed. The collateral agreement was not signed. How does that have to impact the guarantees? Balderdash, right? Attorney Ryan represented these people during the Second Amendment. That was the last loan document, okay? That Second Amendment was signed around the time of his email that I keep referencing to extend the maturity date and give them more time to sort their problems out before Polaris finally called the default, which, by the way, didn't happen for almost a year later. We gave these people about as much time as anybody would. You noted that there was $1.3 million in interest owing when I filed this case alone. We let it go for a long time trying to see if they could sort themselves out. His email as to the Second Amendment says, my colleague at Dickinson says attached is the draft amendment to the reference loan agreement. This is the Second Amendment. Attorney Ryan responds, Mr. Lavender and I have reviewed the amendment. We have no proposed changes to the document. It was then signed. The Second Amendment ratifies every rep, warranty, guarantee, waiver, and release that came before it because that's how this is done in finance. So all of the rest of that clutter can just go right out the window, right? The initial guarantee was signed. The last document that ratified everything between it and that last document was signed. We are in default. Monies are owed, and Attorney Ryan and his clients have admitted repeatedly in this venue and others that they have personally guaranteed these loans. It is an unfortunate situation. It's not personal with me and these guys, but we are entitled to the judgment. That's it.
Okay, let me get Mr. Ryan's response to my question and Mr. Sobczak as it related to, again, the correction and acquiring the additional 1 acre. Doesn't that, again, undercut your argument about this being a breach if it was corrected?
Look, it arises from the guarantees. It's the guarantees that were signed or ostensibly signed at the moment the second loan was made in June of 2022. they have paid $115,000 to the Hollands for that 1 acre, for the orphaned 1 acre. And for that reason, the quiet title action is resolved, frankly. It's
Right,
still-
but I mean, you were interposing it as an affirmative defense, and you went into that quite extensively on your argument, saying, well, they created the first breach because they were aware of this defect and they went ahead with it. And, therefore that should, in some way, ameliorate the guarantees or et cetera. And I'm thinking, yeah, but they corrected that. So wouldn't that undercut your argument on that affirmative defense?
Well, no, because the guarantees are given with the understanding that you're relying upon Evolution's making a valid loan at that time with Polaris in August. And when there wasn't a valid loan being created in August, the guarantees are defective as well.
So I guess I'm having trouble a little bit with that, Mr. Ryan, and because obviously in a lot of these business court cases, like I say, you have personal guarantees. And so what I'm looking at is say, okay, so the individual, the guarantor in those cases could always say, okay, what we're going to do is we're going to have these documents drafted in a way that there's a defect in the original document, and therefore we can get out of the guarantee. I mean,
that's not the case here, though. I mean, they knew from the go that
So did your clients.
Yeah. So Lavender and Flockins knew of the defect at that time too, because they were the ones that were purchasing it, apparently.
Thank you, Your Honor.
Apparently, you have a fan club here.
Yes, well, it's nice to have that.
Well, keep in mind, to be clear, Evolutions, the sole member of Evolutions was Matt Lavender, not Craig Flocken. But so, I mean, that's the argument here, is there was a defect. Actions have consequences. They knew about it. They benefited from it. The fact that they've now resolved it resolves the quiet title action only, but they're still in jeopardy with regard to the guarantees.
Okay, thank you. I haven't heard from you, Mr. Matheson, so I want to let you have opportunity because you've sat there and listened to everything else.
Well, this is fascinating stuff. I'm first in line with Ben Sobchak on your fan club here. So
Okay.
Second.
I know Mr. Sobchak has another motion as it relates to the collateral. The only issue that I'm seeing overlaps here is that First Amendment and the lack of signatures on the documents. I raised it just because I knew that was an issue between the lender, Polaris, and the borrowers, which, depending upon how that comes out, could have a dramatic effect on Polaris's security position. But it's not, I don't have, quote unquote, standing to make that argument because we're not a party to those documents. But what I will say is, because the argument here, at least in context, that Polaris is the sophisticated lender, these documents are vetted and used around the nation. Well, at a minimum, it shows some sloppiness on the part of Polaris's part to loan $4 million and not have all of these documents signed on top of whether it was Polaris and or Evolutions that knew about this title defect and still loaning the money on top of all of these problems. That's, as I said, it's more of an Evolutions problem than it is mine. I just don't want that spilling over into my argument somehow that detracts from the issues that I'm sure will be raised in the context of Mr. Sobchak's argument with Mr. Spakeen.
Okay. Okay, well, then, Mr. Sobchak, I guess the ball's back with you at this point.
Because we cannot get off of it. Again, quoting for Your Honor, Exhibit 12 to the FAC, the First Amendment that everyone keeps talking about. Article 1, first thing in the document. As of the effective date of the loan document, as of the effective date, the loan documents are amended as follows, listing all of these ancillary loan documents and exhibiting them and attaching them as those corresponding exhibits to the document. Does everybody want to debate whether we should have had 16 other signatures gathered on that or not? I don't even think my firm represented them on that part of the deal. I'm not sure, right? But the point is, they signed the First Amendment that said all these other things are valid, and they were attached to the First Amendment. It is completely just misdirection. And then they signed the Second Amendment that ratified all of those loan documents. And even if that wasn't the case, Your Honor knows well that if a document's not signed, but there's still performance pursuant to it, it's still a contract. They took the money, they spent the money, they gave us payments, they made interest payments. What are we talking about here, right? Like, it's completely not relevant to this, your consideration, because what is relevant is they have filed other court documents saying they are guarantors. Attorney Ryan just told you to your face right now that they are guarantors. They signed the initial guarantee. They signed the Second Amendment. The loan's in default. Everybody knows that. They're guarantors. They were the owners. They got salaries. They stood to win really big if this business worked. It didn't work. That's what
So,
happened.
Mr. Sobchak, just to correct, because I kept coming through with the paperwork with that. So they signed the original documents, they signed the Second Amendments, but you're saying they didn't sign the first.
No. They signed the original documents, the initial loan. All of those
Right.
are signed individually,
Yes.
including the initial guarantee of the first
right.
tranche.
And
Then they
signed
signed
this.
the First Amendment, which added money in, and they signed the first document, Exhibit 12. I have Exhibit 12, and then there's Exhibit 12A, B, and C, because they were all attached to that First Amendment, which is why they're not individually signed, because it says by its terms that by signing the first 5-page document, all the exhibits attached to it are also effective as of that date. That's just how it was set up. And then lastly, they signed the Second Amendment when they wanted another extension on the maturity. And that Second Amendment, which Mr. Ryan represented them in the context of, said all the prior loan documents are completely legit, and all the waivers and all the releases, and there's no defenses and there's no set-offs. And that's it. So that's
Okay.
the answer.
I just was trying to get correction because in the documents, it continued talks about other ancillary documents not being signed. I kept coming and go,
That's-
what ancillary
Yeah.
documents? I did.
That's just referencing the exhibits to the First Amendment, and they weren't
Okay.
independently signed because the First Amendment says by signing the first 5 pages, all the exhibits, which are hundreds of pages, are also legitimized and effective. And Attorney Matheson, Attorney Ryan, nobody has addressed at this court the actual words of that First Amendment. And it doesn't even matter, Your Honor, because they validated it again later on the Second Amendment. They signed the initial guarantee, and they've admitted it in court. So this is honestly a waste of time, this argument at this point, but it just keeps getting flung at me because they don't have anything else to say.
Okay. I just wanted clarification
Yeah.
because
And
I kept in the back of my mind as I read that, I keep coming back to that. I go, what ancillary documents are they talking about? Because there wasn't any identified, but
That's
we're
those.
talking around it is all.
Okay. I guess I would lastly say we're entitled to judgment for the full amount. And I would ask again to do the 7-day order thing and put together the mathematics. And I'm sure Attorney Ryan will object. Alternatively, if everybody would like to make our lives easier, Your Honor, they have admitted that $8,312,000 has been loaned in principal, and Your Honor, in a prior order, noted that roughly $1.3 million in interest was due as of the time of the receivership, which was a long time ago. I'll save the 7-day order dance with Mr. Ryan and just take my judgment for 8.3 plus 1.3, which are already established in the record, because frankly, it doesn't really matter because these guys don't have $8 million or 9 or 7. Whatever the court wants to do that's easiest.
Okay. Mr. Ryan, do you have any response to that?
I think if I say anything, we're just gonna replow the same field again.
Okay. I just wanted to give you an opportunity. That's all.
I appreciate that, but I think there's some mischaracterization about what I said in an email. I don't think you're
Would you
gonna
like me to publish it to this group right now?
No, but my
Okay.
point is that I said,
'Cause I feel good about
review
what
the
it says.
amendment. We have no proposed changes.
And then it was signed.
Well,
Okay.
it's an email.
I understand that.
Okay.
I've
Thank you.
looked at, I've reviewed the email, so I don't need to
Yeah.
have it published or anything of that nature.
All right. Thank
Okay.
you.
Mr. Matheson, do you have anything else before we move on
I,
to the last
I
one?
do not.
Okay, Mr. Polderman.
I do not, Your Honor.
Okay, Mr. Sobchak, go ahead with your last argument then.
The last motion?
Yes,
Okay, moving on, changing lanes slightly. So now this is Polaris moving against intervening plaintiff Specken, represented by Mr. Matheson. There are not claims against our respective clients. Polaris is not suing Specken. Specken is not suing Polaris. The reason that we're dealing with this is because Mr. Specken loaned money to entities, including the entities that are part of the receivership, in a second position, junior to us. The loans are not even alleged to have originated until after our first set of UCCs was filed, first mortgage, second UCC, second mortgage. They've all been on file for a long time. So the truth is, because of the amount of money that was put into this that has kind of disappeared, which is a little peculiar, my client's under collateralized, which means that Mr. Matheson's client comes after us is extremely under collateralized and probably, there's not enough at all. So Mr. Specken's only chance here is to create some question of fact about what is the collateral. Otherwise, it's either going to be foreclosed on by my client or we're going to go bid for it. And I don't think anybody's going to outbid Polaris because we got a lot of money and credit coming in because we lost a lot of money on this deal, more than anybody else involved, including the individual defendants and Mr. Specken. So we had this talk before, and Your Honor gave Mr. Matheson and Mr. Specken the opportunity to put everybody on notice of the reasons why they think some of the receivership estate's collateral is not actually collateral, but is, we're using the defined term, the equipment, which belongs to entities which belongs to companies other than the entities, but was then strangely inserted in the Grow building that was owned by Evolutions, an entity. And what he provided the court and us and the receiver was a notice, and that notice attached an affidavit from Mr. Lavender. Mr. Lavender's affidavit says there's HVAC equipment, irrigation equipment, and curing system equipment that was purchased at least in part, right? Which, that is deafeningly loud, at least in part by Mr. Specken's money, with Mr. Specken's money. And more importantly, it also says that this was done to subvert or get around the Polaris loan documents, which prohibited the entities from taking any money from anybody else, specifically to avoid this exact situation that we're dealing with now today. Mr. Matheson's response confirms that Mr. Specken was aware that Mr. Lavender was having money lent to other entities, allegedly, because Polaris's loan documents didn't let him take money into the entity that owned the Grow. Okay. Respectfully, Mr. Lavender is being sued for fraud in like 10 venues right now, right? So his affidavit's worth what it's worth. That is all that Mr. Specken has put up to Your Honor in the notice. So now, discovery has ran. I admit that I still have rolling productions owed to Mr. Matheson, but every document that I attached to my motion has already been produced to him. The dispositive motion deadline has ran. Like, there's nobody can file new motions unless we change the schedule at this point, which I'm certainly not going to stipulate to. So what other choice do I have but to bring this motion to address this issue? Because if it's not addressed, Your Honor, we're all log jammed on closing out this receivership, because we're going to try to go bid this receivership estate, and Mr. Matheson's going to scream and yell that that's not our stuff, or that's not the receiver's stuff to auction or liquidate. And where do we go from there? And how does this ever end if not now? So compare Mr. Lavender's affidavit, which says, at least in part, doesn't say which exact equipment, how much money, when was it purchased, which specific entity of Mr. Spakeen's loan parties was it purchased by, when was it installed in Evolution's Grow, and what reasonable person loans money to a different entity to then use that value to put in another unaffiliated entity's facility? It just doesn't make any sense. But anyways, that's what he's given you. So what I gave you in response in the motion is all of the draw records and all of the construction inspection reports that Polaris received in making the draws of its loans. And we went ahead and we highlighted for you, because they are voluminous, right? All the places where it says that irrigation equipment, HVAC equipment, and other equipment, which is the same sort of stuff that Mr. Spakeen's saying is his, was purchased with Polaris's money and installed in the facility and overseen by, you know, the contractors and lien waivers and the whole process, right? So we gave you all these documents and we said, there's no question of fact in light of what these say as compared to Mr. Lavender's ambiguous at best affidavit that this stuff was purchased with Polaris's money to be put into the facility that is its collateral, and all the stuff in it is its collateral. And, you know, they're just hanging by a thread here because they don't have anything else to offer. That's a great argument, but it's honestly not the easiest one for Your Honor to rule upon. The easiest one for Your Honor to rule upon is under Michigan law, MCL 440, 9334, sub 1. Security interests in fixtures are junior to conflicting interests of an encumbrancer of property. This makes great sense, obviously, Your Honor, right? If a fixture is appended to a building and is part of the building, then it has to be first positioned by the owner of the building. Otherwise, you would have people tearing commercial buildings into shreds, you know, when creditors fight, and damaging property, rendering things unworkable. That's the law in Michigan, right? Fixtures, it doesn't matter. It doesn't matter even if everything that Mr. Spakeen says is correct in that notice and in their response. It doesn't matter if this stuff is a fixture. It still falls under Polaris's mortgage over Evolution's Grow facility. So the question is this stuff a fixture? Well, we gave you the analysis in our opening brief, and we cited case law that says, you know, bank vaults and the like are fixtures because they're permanently affixed to the facility or the thing, that they're incidental to the operation of the facility, and that facility is adapted to that application, and that they're intended to be permanent. HVAC systems that control heating and cooling are like the definition of a fixture. And irrigation equipment is also like plumbing built into the ceilings and the walls and the floors that runs water and feed through the facility to feed the plants. Would anybody argue that the toilet in your house, Your Honor, is not a fixture to your house? I should think not. Why would any other plumbing be treated differently? So that's really easy, right? And it's a great way to just rule as a matter of law based on that statute. In the response, Mr. Matheson does his best here and respect the hand of cards he's holding. He first argues that this is procedurally irregular because we don't have claims against each other. But that's not right, because under 2.116B1, it allows Polaris to move on issues. And here, Mr. Spakeen created the issue by making the assertion that this equipment is not my client's collateral, but is somehow his. And how else are we going to deal with that if not in this setting, in this venue right now? He then argues that our motion was not supported by an affidavit. I'm sorry, I didn't think I had to attach an affidavit to hundreds of pages of like just objective draw requests and photographs of the facility, but we corrected that in our reply. Exhibit B to our reply The fella at Polaris in charge of these things says expressly that it was Polaris's understanding that these equipments were purchased with its money, and then that affidavit validates all of the draw request records and all of the inspection reports that are attached to my motion at Exhibit A and B. So that wraps all that up. The last argument that Mr. Spakeen makes is again criticizing our fixtures analysis because we didn't specifically allege that it was affixed. Like, I shouldn't have to point out that these giant tanks for water are lagged onto the floor. And I shouldn't have to argue that the HVAC systems that are embedded in the ceilings are fixtures. But again, to try to appease, in the reply, we attached as Exhibit C a bunch of photos which are like very recently taken pictures of the facility. Mr. Polderman will tell you that I specifically requested these photos of the estate, and people at the grow took the photos because I asked for them. And they clearly show that this stuff is attached to the walls, attached to the ceilings. Like, just looking at those photos, there's no question that this stuff is a fixture. Lastly, even if that's not the case, because, you know, Mr. Spakeen attacks whether it was affixed, et cetera, et cetera. There's no discussion of the fact that the facility was adapted to use this equipment and the equipment was adapted to be part of this facility. In a world where Mr. Spakeen gets what he wants, they literally go in and tear this building. They demolish it, right? They demolish it. And then what? They have a bunch of used PVC pipe and wires and HVAC ducts and tanks that they truck out and sell used. That leaves this building completely inoperable and functionally worthless. And not to mention, it would probably cost as much to remove all that stuff and do all that demolition as it might be worth, if anything, anyway. But there's no response to that at all, right? The law is very clear that you can't let this building get torn limb from limb when this stuff is a fixture, irrespective of other fights about security and who's first, because it's too damaging to like business and buildings and society and what have you. So with that, I'll give it to Mr. Matheson.
Okay, Mr. Matheson, go ahead.
Thank you, Your Honor. I'm going to need to correct a few things first, some words and phrases that Mr. Sobchak used. In his last argument, I think if I correctly interpreted or heard him correctly, he was saying in the best of Mr. Spakeen's world is that he comes in and demolishes the building. I mean, I haven't used that word. It hasn't been suggested. That's not the argument that's being made here. In the affidavit that was submitted with our response, it was very specific in terms of the equipment that we are claiming a first priority security interest in because it's not owned by Evolution's Holding LLC, which is one of the entities within the receivership estate. So,
Mr. Matheson, those are those four items
yes,
of property that you identified in response to the December 4th order?
That's correct. Paragraph 7A through D of the Lavender affidavit. And while we're on that, I guess nowhere in either the motion or the reply is this equipment addressed. It's not addressed. It generically in the documents refers to electrical, plumbing, in very generic terms like that, but this is very specific terminology here that wasn't addressed either in the initial motion, nor was it addressed in the reply where they attempted to correct the deficiencies in the motion with this reply affidavit, which, setting aside this affidavit, whether it was properly submitted in the context of a reply when these are the very issues that were raised in the motion, but taking a closer look at this affidavit, it's invalid. One, I believe, at least and I don't have an affidavit, and this is Mr. Sobchak's client, but I believe Polaris is located in California, and that's where Mr. Schultz is located. I don't know for certain because he didn't identify that in his affidavit. And in fact, he omitted any mention of ever being to the facility and physically being present, looking at the equipment. I mean, how can he offer an opinion of equipment and how it's attached and where are the bolts and what's affixed if he can't even testify that he's ever physically been to the facility? And I will address that separately after first addressing paragraph 3. This is what Mr. Schultz says. It is Polaris's understanding that all of the equipment identified in Mr. Spakeen's notice of claim to assets were paid for using Polaris's loan funds. It goes on, paragraph 4, that belief is substantiated by, and then that paragraph continues forward. Michigan law does not allow or validate an affidavit based on information and belief. I would refer the court to Soderberg versus Detroit Bank and Trust Company, 126 Mishap 474, 1983. This is what it says, just quoting part of it. The affidavit in support of defendant's motion for summary disposition is signed by defense counsel attesting that the contents of the motion were, quote, true to his knowledge and belief. I mean, those are the words that Mr. Schultz is using here in his affidavit. He has an understanding and a belief. These aren't factual statements that he's making. And as I said before, doesn't even mention any of the specific equipment that Mr. Spakeen has identified in his response in the supporting affidavit attached to the response. So it's faulty from the standpoint of it being based upon an understanding and belief, and also fails because it fails. I mean, this is their motion. They know what the equipment is, but yet they intentionally opt to keep this more macro. Hey, we bought everything in there is ours, but yet they fail to identify any of those specific pieces of equipment that were identified in the affidavit. And to Mr. Sobchak's point, I mean, we're not trying to delay a sale. If that's what Mr. Sobchak and Mr. Polderman want to proceed with, more power to them. I mean, the orders entered. I have not said anything to hold back on the sale. They could do that tomorrow. My argument is that there's an easy solution to this, and that is allow Mr. Spakeen to remove the property that he has a first security interest in. We're not going to demolish the building. It's very specific in terms of what that equipment is. Enter an order, we'll come in, remove that equipment, and they can have at it with the sale as quickly or as slowly as they want to. But it just can't include the equipment that we have identified, claimed a first priority security interest in, and supported that with legitimate affidavits and supporting evidence. I have a note here also as Mr. Sobchak was making his argument that somehow we were making a claim on this whole fixture argument that we were entitled to remove the HVAC, heating, ventilation, air conditioning. That's not what the affidavit says. It says controls for HVAC units. We're not making a claim to HVAC. We're not making a claim to the heating ducts, whatever. Candidly, I don't even know what the HVAC is, and I don't want to speak out of turn, but that's not what we're arguing here. And what that does, I think, is clouds the issue of whether or not this stuff is actually a fixture, which is what Mr. Sobchak argued for his motion. And so in the initial motion, there's this reference to a case, I think it was the Michigan National Bank case, talking about bank vaults and drive-through deposit tubes and concrete slabs. I mean, that case doesn't have any applicability here. And so without an affidavit or other supporting proof, we responded and said, hey, I mean, that's not what's there. This is the case that's more applicable here, because what we're really talking about is tanks, tables, computer equipment. It's more of a system, but again, I don't want to beat this horse to death, but I mean, we're not coming in there and ripping things out of walls and the like. And so the affidavit that is supported or filed with the reply, which again could have been attached to the the original motion, and we could have then responded to it at that point. It's just a blanket conclusion without any real supporting facts. In fact, I would argue that the photographs that are attached contradict what Mr. Schultz testifies to here. And also, again, there's no foundation that he's looked at anything other than photographs here, but I don't see any equipment, the tanks that are actually bolted or installed into the foundation, which is what Mr. Schultz testified to. Man, it's hard to see much of any bolts or any attachments whatsoever here to the equipment that Mr. Spakeen actually makes a claim to. So the affidavit is deficient in that regard as well, because it lacks any proper foundation. There's no specificity in terms of what's attached where. And in fact, the photographs that are attached contradict Mr. Schultz's testimony. I'm going to wrap this up with just a general comment here, and that is, these affidavits, at a minimum, and I think what Mr. Sobchak said is that sort of this first argument over who owns what is not an easy situation to solve. And then that's when he went on to this fixture issue. And I agree. I would argue that the evidence more clearly shows that this is not part of the receivership estate. It's outside of the receivership estate, and that's based upon the affidavits and evidence or lack thereof when it relates to Pelorus in terms of the ownership of that and it not being contradicted here before Your Honor. I would ask that Mr. Spakeen be permitted to remove the equipment that he has a first priority interest in, let Pelorus proceed forward with its sale, and or at a minimum determine that there's a question of fact here in terms of who owns what and what Mr. Spakeen has a first priority interest in. These affidavits, again, I'm convinced that their affidavit does very little to solve it, but if you give it any weight, it creates an issue of fact. And that's probably why it wasn't attached to the motion in the first place, is that it was an intentional omission to see what the response came in with. And then the affidavit gets filed, which really creates an issue of fact when you start looking at it, if you give it any weight whatsoever. And as this court is aware, the rules of summary disposition, I know I cited it in the brief somewhere, that a genuine issue of material fact exists when the record giving the benefit of reasonable doubt to the opposing party. We're the respondent. We're entitled to the benefit of the doubt as it relates to this equipment and who owns it, and indeed what is or is not a fixture here. And they haven't identified this equipment, how it's attached, where it's attached. I mean, it's just they haven't presented sufficient evidence to support this court awarding it summary disposition on these matters. In fact, I believe that the evidence shows to the contrary, or at a minimum, there's an issue of fact here.
Okay.
Thank you.
Mr. Matheson, I did have a question. When you're talking about the equipment and other personal property, I think in some place in the documents, I don't know if it was the notice of claim or what, where you said that it was paid for at least in part by loans from Spokane. Well, where's the other money from if it was only paid for in part?
So when I read that originally in the affidavit of Matthew Lavender, it says the proceeds from the loans made by Eric Spokane were used at least in part to purchase equipment. So Mr. Spokane made multiple loans to, we'll just call them the Evolution entities. And this says the proceeds from the loans made by Mr. Spokane were used at least in part to purchase equipment. So I identified in the response, not all of the loan proceeds were used to purchase this equipment. Now, I'd have to go back. I'm not aware of a statement that says that equipment was purchased by somebody else. And in fact, I identified that Mr. Spokane loaned money to Evolutions for other purposes. So our position is that, as far as we know, the loans for that equipment, there were no other loans that were provided for that same equipment, and I believe the affidavit supports that.
Okay, thank you. Mr. Sobchak.
Okay.
You're muted. You're really muted.
Better now?
Yeah, hardly can hear you. I don't know why, because what happens is as it goes on, it gets better and better. So I don't know why when you're not speaking, unless sometimes you have those.
Better now?
Nope, we can hardly hear you now.
Man.
You might have to leave the meeting and, try to enter again.
Yeah.
Can you hear me now?
Yes. Can hear
Okay.
you now.
We switched cameras. Look at different profile. We've been
Okay.
been looking at me for a long time. We'll change angles. Okay. So firstly, I am shocked that I am, that I and my client are being attacked for lack of specificity in this setting when we have provided hundreds of pages of draw requests, construction inspection reports that have appropriate headers and clearly look legitimate, and contemporaneous and recently taken photographs. All Mr. Spokane has given you, Your Honor, is that paragraph 7 of Mr. Lavender's affidavit, which says trickle ease cultivation and irrigation system. The only word that's not included is trickle ease in our documents. Okay, so, shoes, Nike shoes, Adidas shoes, they're still shoes. There's only one irrigation system in the building, and we gave you a multitude of documents that say that the irrigation system was paid for and installed prior to Mr. Spokane's involvement with Polaris's money. And yet he's telling me I'm not being specific enough just because this says trickle ease, whatever that means, before it. The next one is controls for HVAC units. Okay, so what does controls mean exactly then, right? Here's an example. Let's imagine that they don't actually mean the entire HVAC system. Well, Your Honor, if your toilet is a fixture and I can't come take that out of your house, can I just take the lid? Can I just take the lever that makes it work? It's all part of a system that makes the building work, right? The controls, whatever they may be, and this is what he set up, right? Just controls, no names, no item numbers, no VIN numbers, no invoices, nothing. Then number D, again, we're talking about me not being specific. Ancillary and other equipment. End stop. What could that be, right? But I'm not being specific. I also agree with you, Your Honor, that Mr. Lavender's affidavit where he says at least in part is at best ambiguous as to whether it means in part like all of Spekeen's money plus other, or in part like only in part relative to the equipment. And there's no way to remedy that here, so you have to take it for what it's worth. So all we have here is that ambiguous statement, and then the only difference between what I've given you and what he's saying is his says trickle ease at the front of cultivation and irrigation feeding system. That's the only difference, right? Okay, fine. So let's move on to the affidavit. One, Mr. Schultz absolutely lives in Connecticut. The idea that, like, what does that have to do with anything? I talk to him all the time. Do you want to know his phone number and what the extension is? It's clearly a Connecticut number. That's where he lives. Polaris has people that work remotely. What does that have to do with anything? The next thing that I think is very interesting about that argument as to the affidavit is, you know, Mr. Matheson says, well, Mr. Schultz says he believes, and that his belief is substantiated by these documents. Okay, so that's not the same as saying upon information and belief, and we all as attorneys know that that's a specific turn of phrase in the law. Belief, if I had not used belief and said it was our understanding, right, or our position, what is the difference? There's synonyms, okay? He's not saying upon information and belief. He's saying that Polaris believes that this was all paid for with its money because Mr. Schultz's job is specifically to administer the loans and deal with the draw requests and make sure that, like, they match up to money going out and things got closed up, and they use third parties, service providers, which are where those documents came from, and inspectors and the like. So all of that is just like completely, again, smoke and mirrors. And, you know, at the end of the day, he's telling you that I haven't proven my position. If this was so slam dunk that that Mr. Spekeen wants to just come in and start taking stuff out of the building right now, why have they not given you any invoices, any bills of sale, any records whatsoever that says, hey, this is the day and time when this entity that is not part of the receivership bought these equipments, and these are their VIN numbers, and now let's go look at them and see if they're the same things that are in the facility. He is the one who made this issue. While I am moving here, this is his burden to show that this stuff is not collateral. And all he's given you is this vague affidavit, and then he's criticizing us for giving you hundreds of pages of pictures and draw requests and inspection reports that are supported by an affidavit, because I didn't think I was going to have to do that. And one of the reasons for that is because it's clear law that I don't have to lay foundation for evidence in a summary disposition setting. Like, that's not how C10s work, right? The court takes it for what it is. But we gave an affidavit, so that solves that. Here, I wish I could do this better, but like, there is this photograph, okay? That's what we're talking about. Look at, Your Honor, it's lagged to the wall. It's all piped in. Right here, this is all bolted to the floor, and it's the support system for this tank, so it stays where it's supposed to be. How are we reasonably arguing about whether this stuff is a fixture or not? This is the irrigation system that makes the building work. So, you know, the idea that you're going to rule right now that Mr. Spekeen can come start just taking stuff out of a regulated cannabis facility is preposterous based on Mr. Lavender's affidavit alone. Quite the contrary, right? I have given you a bunch of paperwork and an affidavit that shows this stuff was purchased by my client, and they've given you nothing. No invoices, no emails, no VIN numbers, no dates, no dollar figures, no nothing in response. Now, Mr. Matheson knows this, which is why he ends with, and if you know, at best, there's a question of fact. Okay, well, where is that question of fact going to end? Because he just told you that his position is we can do the sale as long as he comes and gets his stuff. Your Honor, if I tell you to sell your house and before you do it, I come take out your toilet and your sink and part of your HVAC system and your garage door and whatever else, are you going to still be in a great position to sell your house? I should think you wouldn't, right? So the fact that he says that so flippantly is frankly aggravating, because it would decimate the value of this facility to anybody who was ever going to use it again. Decimate it, right? Absolutely. There is no question of fact created on the record before you, and that record is closed because discovery is closed. And Mr. Matheson and Mr. Spakeen didn't depose anybody. They didn't ask to inspect the facility. They just gave you this affidavit from Mr. Lavender, which doesn't really say much of anything, as you pointed out. So if not now, how does this end? How does this end? Because if if you don't rule in favor of me right now, and Mr. Polderman goes and says, okay, we're going to bid this stuff, Mr. Matheson's going to object and try to stop that because he's going to say he still has his assertion of right. But that is itself not a claim against anybody. It's not supported by anything. Discovery's closed. He didn't file his own motion. Are we just going to indefinitely sit here and wait for something to happen? Like, it's preposterous. So I'm again asking you to rule in favor of Polaris that Mr. Spakeen, at the court's direction, was told to put it on the table why he thinks this stuff is his. He gave you what he gave you. I gave you a lot more in response. All those facts shade our way substantially, and to the point where there really is no question. And there's no real opportunity to put anything else in the record right now, so we can close this up now so we can all move on with this receivership. The only other alternative, I suppose, would be, I guess if in some future setting they proved this up, they could have like money damages against whoever won the bidding process. But I'm not going to entertain that right now because they haven't even created an issue for you to rule upon. This affidavit means nothing. And I know that you looked at the picture I put in front of you, and I have attached many more to the reply. There's just no way that anyone can argue that this stuff's not affixed to the building, and Michigan law means that's the end of the story. So that's it.
Okay, thank you. Mr. Matheson, anything else?
Just that, I mean, we're all in favor of moving this forward, but it can't be at our expense. If Mr. Sobchak needs to do some more homework to make that happen so that this is done correctly, so be it. And this idea that Mr. Spakeen is held to some higher standard than his own client, who has really the burden when he files the motion to come forward with all of the evidence, and they haven't done that. And so
I'm sorry. I have to.
I'm sorry, Ben, but you've had your opportunity and you keep doing this. Let me finish. We can't be held to some higher standard than even what they are. And that's what he's trying to impose here. And that's just simply not right. So thank you.
Thank you.
He's misinterpreting what I said.
Okay, I don't need anything else, Mr. Sobchak.
Okay.
Mr. Ryan, anything else from you?
Yeah, in the exchange that Mr. Sobchak and I had, there was sort of an offer that if we would stipulate to the guarantee of the first 4 million, that would suffice. And I've been in contact with my client here while the other motion was being argued, and we can stipulate to that as long as we can get a dismissal of all the other causes of action that Polaris has against the individual defendants, Matt Lavender and Craig Flocken. So if that's still on the table, we can accept that and make your job a lot easier here.
Okay, Mr. Sobchak.
That's not what I said. I did not offer to stipulate to that. Okay. I haven't cleared that with my client yet.
Okay,
what I said is, based on their arguments, there is no question as to that first chunk. I win on that irrespective. I don't have to stipulate to it. But I'm not going to yield on the rest of the points at this point to horse trade with him at this time. If Mr. Ryan wants to call me after this and have a discussion, but no, I don't agree live in a hearing to a deal.
Okay, that's fine. That's fine.
That's not what I said. I didn't use the word stipulate.
Mr. Polderman, anything else?
Your Honor, I would just point out the obvious that this is a grow facility with live plants, and that pulling out the irrigation system, HVAC controls, and other pieces of equipment will be fatal to the facility. It's just, We thought we were going to have to close it down a month ago. We've been able to keep it together here with chewing gum and baler twine effectively. We can't grow plants without a irrigation system or HVAC controls. So to have Mr. Spikeen come in and just pull stuff out would force a shutdown. That's really not a viable alternative. And I would just point out, as far as the photos, I've been in the facility. I do believe the photos are accurate. I did ask for the photos from a person that was on site at the facility. I believe them to be true and accurate because I've been in there, and all of these systems are in fact screwed or affixed to a wall or a piece of metal that's attached to the wall. I'm scrolling through them. I've been in the facility. I do believe they are accurate of the systems that are there and are integral to growing plants indoors. And without that, we will have to promptly close the facility.
Mr. Polderman, I guess the only thing I would ask is, obviously what I'm going to do is take the two other motions under advisement and give you a written opinion. Mr. Polderman, if you could provide the court at least with an affidavit to the extent, as you say, about being affixed, the court would appreciate having that in the file.
Thank you, Your Honor. I'll do so. Could I have maybe till next week, Friday, to submit that to the court?
Certain, that's fine.
So that's a bit problematic for me, Your Honor, in terms of this evidence coming in after the motion has already been filed and decided. I mean, this isn't an evidentiary here. I don't know what the purpose is of that, and I know sort of Mr. Polderman was sort of just testifying, but
I
mean,
understand.
that's problematic unless we're going to have the same right to address factually what Mr. Polderman is saying. I'm not seeing the same things from these pictures. So I just have a real problem with that in general, but I don't want to speak out of turn. If you had some other ideas regarding what you were going to do with that affidavit.
No, it was something I wanted in the file. I guess once you receive that, Mr. Matheson, if you have I guess I'll give you 7 days thereafter. So he has until a week from Friday. You'll have 7 days thereafter to Mr. Polderman. Can you provide Mr. Matheson or someone, whatever, access to the facility so they could do their own affidavit?
Sure, that's not a problem.
Okay.
And this is just me thinking out loud based on a couple of other cases where, and I don't know how the court would feel about this, but where the court has actually traveled to a facility and counsel for the parties are present, walks around and makes its observations and then goes from there. But I realize that's a little unusual for the court to take a field trip, but the facility is certainly open and happy to provide access to anyone and everyone.
Okay, Mr. Matheson, what's your response to that? Rather than doing affidavits, if we just visit?
Well, I mean, an affidavit would be a lot more straightforward. I don't know if I'm going to be there, who's going to show up. The logistics of this, I mean, now we're really getting further.
Hey, we are.
Yeah, I mean, I'm just concerned about this in the context that it's been raised. I'm not opposed to it. If after you rule on this that you want to take a field trip.
I don't want to do it after I rule. I want to do it before I rule.
Can I say something?
Yeah, go ahead.
So this is, again, Mr. Matheson arguing negatives as affirmative statements, right? So, you know, he complains left, right, and center that there's not enough evidence and there's a question of fact. Now, Mr. Polderman, who is an officer of the court, remind everybody, right? He represents the receiver or is part of the receiver's office. Like, that's the officer of the court and technically like the court is saying that he's been to the facility and worked it, and these are the things. And he offers to give the court an affidavit to support that. Mr. Matheson, oh, whoa, hey, I don't want new facts coming in that don't support my position, right? I don't want any of that. So then we go, okay, cool. Let's go all visit the grow and look at it together, right? A great way to end this. oh, hey, I don't know if that makes sense either, right? He wants you to rule now because he knows he's going to lose because this is just a fact that this stuff
This is
a
ridiculous,
fixture.
Your Honor. I mean,
Okay.
this has taken on a life of its own. I mean, I know that Mr. Sobchak and Mr. Polderman are kind of hand in glove here, but I mean, this just who's going to be there? Who's going to see what evidence is taken? I mean, I don't know. I'm concerned. I'm not saying I'm opposed to it, and I don't appreciate words getting put in my mouth as Mr. Sobchak is trying to do here. But I have a concern with it because of the unknowns of how and whether this is even necessary. It was their motion. They provided everything that they had to support the motion, and now we're talking about adding more evidence and information that they failed to provide on their motion.
Well, I don't know if failed to provide or just more documentation or confirmation. But what I'll do is I'll let Mr. Polerman, you can again do the affidavit as the court suggested a week from Friday. Mr. Matheson, you'll have, if you want to get with Mr. Polerman, you can get in before then. You could get your affidavit sooner, but I'll give you 7 days after his affidavit's due to do that. If you can come in with some contrary, or I guess evidence or documentation showing that they're not attached or
Sure.
something of that nature, you can do that. If there's a dispute after all of that, and when I see it, then we may make a visit to the facility. I hate to do that, but if we have to, we'll do it. But at this point, we'll take it under advisement and subject to those two potential affidavits and a possible visit if we need to.
Thank you so much for your time, Your Honor.
Okay.
This is-
Well, thank
Thank
you
you,
all as
Your
well. I think we've got it all done at this point, other than, again, that additional information. So
Thank
thank
you.
you, gentlemen.